Good afternoon. I'm Andrew Ullman. I'm a partner in Mayor Brown's Washington, D.C. office and a member of its financial services and public policy practice groups. I'll be moderating today's webinar on the Federal Deposit Insurance Corporation's recently proposed guidelines on corporate governance and risk management. We have a terrific panel today that will explain the proposal and discuss some of the practical impacts the proposal could have on FDIC-supervised banks, as well as some of the public policy implications raised by the proposal. To lead off our discussion today, our first panelist will be my colleague, Larry Cunningham, who is a special counsel in Mayor Brown's New York office. Larry is a member of the firm's capital markets and public companies and corporate governance practices. He's a recognized authority on corporate governance and corporate law, including having received the B. Kenneth West Lifetime Achievement Award from the National Association of Corporate Directors. Larry is also the Henry St. George Tucker III Research Professor of Law Emeritus at George Washington University. For our discussion today, we're thrilled to have three excellent panelists. First, Brandon Milhorn is President and CEO of the Conference of State Bank Supervisors, the National Organization of State Financial Regulators. Brandon has held senior leadership roles at the FDIC and Raytheon, and served as counsel for the Senate Committee on Homeland Security and Governmental Affairs, the Senate Select Committee on Intelligence, and the CIA. Patricia Murphy is a partner at the global management consulting firm of Alvarez Marsal. She is one of the leaders of its financial services practice and has over 20 years of experience working with financial institutions. Patricia has a background in legal and investment banking and has advised many organizations in reviewing and building their corporate governance, risk management, and compliance programs. Finally, Dale Hale is the vice president for trust. Dale Baker is the Vice President for Trust Policy at the American Bankers Association, which represents the nation's banks here in Washington, including FDIC-supervised banks covered by the FDIC's governance proposal. Thank you all for joining us today. Larry, would you begin by walking us through the FDIC's proposal with respect to corporate governance? What would be the new expectations for FDIC-regulated institutions?
Yes, thank you, Andrew. I'm happy to be here and welcome to our guests and everyone listening in. High level, the FDIC on October 3rd, 2023, published this proposal for corporate governance for the institutions it regulates that have 10 billion or more in assets. The corporate governance proposals are extensive, rigid, intrusive, and unorthodox, and would apply to a wide, diverse group of state chartered banks. The proposal was controversial from the start. The board voted it up by a 3-2 vote, with Vice Chairman Hill and Director McKernan, issuing sharply critical dissents. The FDIC initially put the proposal out for a 60-day comment period, but extended that for another 60 days at the urging of numerous affected organizations. The FDIC has posted nearly 70 letters, comment letters, and virtually all of them oppose the proposal and identify significant problems with it. Only a handful of the comment letters are supportive. So it's and we can dive into the details, Andrew, but that's the broad framework.
Sure. And then also the FDIC's proposal also includes new risk management standards that it's built around the three lines of defense approach. Would you walk us through those proposed standards and how they interact with the corporate governance aspects of the proposal?
Yeah, they're equally bold, although many of them align a little more closely with existing practice and standards, especially they largely track the OCC's heightened standards, although there are some deviations and some details that are controversial. And again, the dissenting commissioners highlight those peculiarities very carefully.
Right. Now, the proposal is been issued as guidelines as opposed to regulation. However, the FDIC was clear that there are still penalties for non-compliance. Can you walk us through what those are?
Yes. If an affected bank were to fail to meet any of the elements in a finalized standard, the FDIC could require it to submit a compliance plan to get into line with the requirements or take other action within the FDIC's discretion, depending on the circumstances. So these are real regulations, not just advice or guidance.
Well, when would the proposal go into effect?
It appears that the proposal would be binding immediately upon its adoption to banks that are within its scope, and likewise would instantaneously apply to any bank that triggers the asset level without regard to any transition and without really appreciating the enormity of the scope and complexity. And that was one of the common themes in the comment letters, was that any proposal of this sort would require a significant implementation period.
All right. And it's also, I thought, interesting that the FDIC reserved its authority to impose the guidelines on institutions that are below the $10 billion threshold based on the risks and nature of the operation of those institutions. So it really potentially has even a broader coverage then.
Yes, and it's got many problems, and maybe we'll dive into them. And I think the comment period has been extremely productive in pointing out the many problems. So I expect significant change.
So let's walk through some of those specific problems, Larry. I know you drafted the comment letter for the Society of Corporate Governance that went through the proposal in detail. Let's start off with the critique that you have in that letter about how the proposal misconstrues and conflates the roles of the board and management. Can you explain this problem?
Yes, thank you. And this is a fundamental flaw in the proposal, and our letter articulated it clearly, and many of the other comment letters did as well, especially from the corporate governance community, because there's a fundamental difference between boards of directors and managers. Boards of directors have oversight authority and are not involved in the day-to-day activities of any institution, including a bank. The managers have the day-to-day operational strategic implementation roles, but the proposal just conflates or ignores this difference by assigning to the board of directors a whole host of managerial functions. It has them establishing the corporate culture in the organization. It has them shaping work environments, down deep into the organization, tellers at a bank. It has them developing ethics codes, writing operating policies, and many other things. Boards certainly oversee such activities. And there are some regulations that have boards overseeing a code of conduct or an ethics manual or employee compliance policies. But it's management that's responsible for articulating, implementing, enforcing all of these elements. And so it's just a fundamental misconception of the roles of these two entities that it would effectively unravel corporate governance. And so we very critically engaged with this part of the proposal and called the FDIC's attention to some standard corporate governance literature that outlines the boundaries between boards and managers and explains why it's so important to the healthy operation of an organization. And we're concerned that the proposal would actually impair corporate governance rather than make it more effective.
Another piece specific out of the proposal is that requires the board of directors to look at the interests of all stakeholders, and it lists has a long list there, not only shareholders, but it also has customers, depositors, and includes the general public. But how does that interact with the traditional duties of directors, particularly under state law?
Yeah, that's a really good example of very inadequate thinking. In the United States, there are numerous different corporate governance models, numerous different laws that articulate the beneficiaries of a board's fiduciary duties. The most common formulation is that directors owe their fiduciary duties to the corporation and its shareholders. Full stop. There are some states that add that a board may or must take into account the interests of other constituencies, and it often names employees, customers, and suppliers in such a list. Other states say that, well, if a corporation is in the vicinity of insolvency, the board's duties shift from the shareholders to the creditors. And I could go on with the various formulations of board duties across the 50 states and other jurisdictions, but the proposal ignores all of that. And it applies to banks that are in 30 plus states. And so you have to attend to the state law duties that boards of directors have. And the proposal doesn't. And it picks these eight or so different categories of constituents, as you said, depositors, customers, communities, and the public. And it is a unorthodox presentation, even if you can find talk about the idea of other constituents, but there are a couple of wild things about the choices that the agency made. It actually ignores employees, which whenever you see a list of all the constituencies of a corporation, the employees are toward the top. So it's bizarre when the agency says, oh, here are the constituents, to leave that group out. And as you said, it includes the general public, which is there's no principle, there's no orientation, no constraint. And it also includes regulators, which again, in a lot of talk, regulators are listed as a constituent or beneficiary of direct or fiduciary obligation, but there's no law that says that. So it's troubling on its merits, but really on just the lack of understanding of the landscape.
One additional variation on this, though, is that in several places in the proposal, the FDIC specifically, though, talks about how directors have to be conscious about the difference of interest between the covered institution, the IDI, and its parent holding company. So even though it talks about shareholders as being one of the stakeholders, they have several places throughout here where the interest, it clearly indicates that the FDIC expects the board to have a manage for the IDI's interest as opposed to the holding company. Can you walk us through, because most of the institutions that are going to be affected here have holding companies as well, that above the covered institution. How does this new guidelines interact with the operation of the board, interaction between the boards of the holding company and of the IDI?
Well, that's a serious problem. I think another serious problem is that the regulation is very often inconsistent with existing regulations, not only in general corporation law, but within banking regulations. For example, many banking organizations have overlapping directors between that holding company and the bank, but the proposal would seem to eliminate that possibility. It seems to indicate that a director of a bank board wouldn't qualify to be a director at the holding company. And so that's a serious problem. And again, many of the letters called the FDIC out on that one.
Now, I want to kind of turn to our panel now and open up the discussion. Patty, I want to follow up on Larry's concerns about the rule misconstruing and conflating the roles of the directors and officers. From a practical perspective, what impact would that proposal then have on the kind of actual operation of the bank?
Well, first, I want to say that we are very hopeful that the FDIC will take into account all the constructive comments they've received to date and revise the guidelines accordingly, especially around the corporate governance issues. We see the most issues and concerns around that, not as much as in the risk management side of the proposal. As you can see in the draft proposal, the FDIC had intended, at least they stated, that they were bringing this proposal in line with what the OCC and the FRB already have in place for heightened scrutiny of more larger and complex institutions. Essentially, they think they're closing a perceived gap especially between the 10 billion and the $50 billion size of institutions. However, there definitely are differences in what they're putting in this proposal versus what the OCC and the FRB are holding their bank constituents in, and what standards they're applying. So we're hopeful that when the new draft comes out, that they will harmonize some of these issues, especially the issues that Larry has highlighted and most of the commentators in these letters have highlighted, and that they won't create an additional regulatory burden or have inconsistencies and more additional issues that banks need to deal with. That said, I do think we can all agree that some version of the guidelines will be adopted. So from a practical perspective, to your question, our advice to our clients when we're talking to them is banks need to start preparing now, especially as Larry indicated earlier, it's unclear from the guidelines as to what ramp-up period they will have to come into compliance with the guidelines when they were adopted. The good news, if there is some, is that every bank does have a risk management program in place. They are continually balancing the risks and rewards in their day-to-day operations as they run their institutions. Based on our experience, we at A&M believe that most affected banks will find that they have many of the basic elements of the requirements, and they're not going to need to completely reinvent themselves. Well-run banks are identifying and managing the risks of their organization, even though they may not be doing it exactly in line with what the proposal says. The FDIC said as much in the proposal, that they said that their belief was, by their estimates, that most, if not all, of the covered institutions, as part of their current standard governance and risk management practices, maintain procedures that are addressed in the proposal. Banks may need to repurpose what they're doing. They may need to enhance what they're doing, but they do have the basic elements to start building out the programs in compliance with whatever guidelines come out at the end of the day. So our guidance from a practical perspective is, especially on the risk management side, because we do believe that a lot of the corporate governance issues will be worked through for a lot of the reasons that Larry has stated, is that they should start preparing now. They really need to start doing an analysis and assessment of the current state of their risk management program and what procedures they have in place and what the gaps would be to align to the current guidelines or the proposed guidelines, I say. The one thing that I thought was interesting is, and Larry touched on it earlier, is the idea of making the 3 lines of defense mandatory. While the OCC and the FRB have strongly encouraged institutions and best practices for a very long time in the industry, as well as other sectors, has been to implement the 3 lines of defense, it's not codified as being mandatory, where this proposal would make it mandatory. So for those of you who don't know what the 3 lines of defense are, it's a very straightforward concept in that the first line of defense is your business team. The business team are managing your company. They own the risks, and they're supposed to have processes in place to manage those risks. The second line are your risk management compliance professionals who provide advice and guidance to the first line, and they also monitor and test what the first line is doing with respect to managing the business risks. And then the third line is audit. And so this is requiring to create a chief audit officer, an audit function if you don't already have one. And the audit function obviously comes in over the top and looks to see if the risk management program is working and it's reliable and the board and management can rely upon it. So there are definitely some new things here that people need to start addressing. And so from a practical perspective, Andrew, people need to get on this now and start to get an assessment of where their risk management programs are.
I want to follow up on another area of kind of practical implications, which is on M&A transactions. Anytime you're talking about duties of the board, M&A transactions are usually where a lot of the case law gets made. Patty, what do you see the impact on the boards and management's ability to conduct M&A transactions from this for the new guidelines?
Well, I definitely see a couple of impacts there. The one overarching construct of a risk management program is your risk management program is supposed to be an organic, evolving thing, and it's supposed to be adapted based on the size and complexity of your organization. So in an M&A context, if you're already subject to the guidelines and over $10 billion, when looking at a potential acquisition, you need to think about what the current state of your risk management program is, as well as the organization that you're acquiring. and look to see what sort of enhancements or build outs would be necessary for the new business, especially say if you're going into new business lines, you're going to offer new products, services, moving into new markets. Obviously, your risk management processes need to evolve with that. And again, the same kind of construct if you're looking at MOU, if you're looking at two organizations that are maybe below $10 billion currently, and when they're combined, they're going to exceed the $10 billion threshold, then you're going to have to look to see which of those risk management programs are capable of managing the larger organization. And the costs of enhancing that program. So what we're encouraging clients to do is it's part of your due diligence process that they should include corporate governance and risk management programs as a key element to avoid any unforeseen obstacles to the transaction, including additional operating expenses as they build out the risk management and corporate governance functions and any barriers to regulatory approval. Being able, in our view, to demonstrate to the regulators that the acquiring institution, the combined organization, has a plan at least for having a compliant governance and risk management program post-deal will ease the path to regulatory approval, as well as minimizing any surprises with respect to integration costs.
Well, I'll do another follow-up on that. Is what other compliance costs do you see for banks from this new guidance?
Well, I think that the issues there is that there's a numerous costs, frankly. It's the costs and the time and the resources of your people doing the assessment of where you are, doing that gap analysis on your program. Most banks that we're talking to are looking to have, especially the boards and some of the corporate governance issues around the board, they're looking to get third parties to assist with that assessment to give them some additional comfort. The costs of additional personnel, there's a requirement to have a chief risk officer, other functions within that, a chief audit officer, and all the staff that goes around that. You'll also need to have potential risk professionals in the frontline businesses. Our larger clients have not only in the business lines, they have people whose function is to manage and monitor the risk in the business lines as well. So we see not only in the build out of the program, but the maintaining of the program with the personnel and resources that will be needed to do this, especially when adapting to the 3-line of defense risk management model.
What about for the availability and cost of D&O insurance?
Well, D&O is always an interesting conversation, right? So, for some time, D&O insurance coverage has been evolving in complexity and cost, right? Boards and management are already subject to claims about errors and omissions, regulatory issues, shareholder lawsuits. However, my colleagues in A&M's insurance practice point out that the proposed standards bring these risks into much sharper focus. And this would be a good time to conduct a full appraisal of your coverage to address the new board responsibilities and any potential new liabilities associated.
Well, with that, let's turn to Brandon now. Now, Brandon, you've heard Larry talk about the changes in how the FDIC will interpret duties and have a much stronger federal approach to the obligated duties of directors. Given that we have a long-standing dual banking system and the states and federal regulators jointly oversee the regulation and supervision of state chartered banks, what's your view about the potential impact here of the FDIC's proposal, and how does it fit within our existing regulatory framework?
Well, thank you, Andrew, and thank you for putting this panel together. I think I could listen to Larry and Patty talk about the implications of this proposal for the rest of the afternoon. From a state regulatory standpoint, our regulators that we represent, they support strong corporate governance standards. And as I think Patty and Larry both mentioned, there are elements of the FDIC's proposal that you find at any bank with strong risk management culture and processes. The challenge with the FDIC corporate governance proposal is it's more micromanagement than risk management. And at a time when institutions should be really focused on core financial risk, the proposal risks diverting their leadership focus into a more check-the-box corporate governance and risk management structure than I think we really would prefer at this time. And I'll come back to this at the end, but I'm not sure that the justification for this is there, that there's a factual predicate for the significant intrusion into corporate governance. But from our perspective, I think there are three particular areas of concern. And the first is the significant intrusion, as Larry pointed out, into the traditional corporate governance role of the state. As you mentioned, Andrew, these are all state chartered banks. They're state businesses, they're state corporations. And there's over a century of law and precedent around the fiduciary responsibilities of boards to the corporations, to shareholders, to the application of the business judgment rule, to their decision making. And the FDIC's proposal would just set aside these traditional rules with really, I think, very thin justification and replace it with a broad duty to a laundry list of additional constituencies: depositors, creditors, customers, the public, and regulators. I'm not sure how you balance as a board. I'm not sure how you balance those competing responsibilities. And at the end of the day, I sort of question whether the vague safety and soundness standards that were in Section 39 of the FDI Act that the FDIC relies on for authority here are really sufficient to justify the FDIC's preemption of these traditional corporate rules that states provide. As I said, I think the justification for the rule is very thin. I mean, basically, you'll see throughout the proposal, better run banks fail less, and they're less costly when they fail. Now, there's no additional justification for that. There's no additional edification of that. There's no analysis of the 57 or so banks that would be covered by this. Where are the deficiencies? Which banks are deficient? In fact, as Patty mentioned, a lot of the banks have very similar structures in place. I think the question in my mind, as we think about the justifications surrounding the rule, are: one, did the FDIC have the authority to pass this rule in the first place? Second, is there a sufficient justification to do so? And what makes the particular rules, the particular framework that the FDIC put in place, not as a best practice, but as an enforceable guideline, what makes that the best approach? And I just think there's scant justification for that in the proposal. So I think that's the first concern, is that significant intrusion into traditional state corporate governance roles. I'll talk about two additional areas because I think they're important. One is the majority independent director requirement and the limitations on directors serving on both the holding company and the bank. Larry mentioned this, along with, this is the third issue, sort of the confusion between the role of the board and bank management. So when you think about this expansion of the duties of the board of directors, the requirement for additional directors because of the majority independence rule, the confusion between the roles of the board and bank management, I sort of question how, as Patty mentioned, the liability concerns associated with serving on a board and how that's going to impact banks' ability to recruit directors. It's already a challenge to find well-qualified directors to serve on institutions' boards. I can't think of the challenges that this, rule would impose on rural banks, smaller institutions. How are you going to find enough directors to meet all these requirements and are willing to serve under these vague liability constraints?
So I want to follow up on something you mentioned at the beginning of your remarks, is about how the guidelines could preempt the business judgment rule. And in your comment letter, you made a very interesting point that I think deserves some more attention and elaboration, which is how the proposal could impact how the FDIC resolves failed banks as the receiver by effectively preempting the business judgment rule. And can you just walk us through a little bit more about your concern there?
Yeah, it's a little bit complex, but I'll try. So, the FDIC,
this is really where the business judgment rule comes into effect, though, and that's really where it's valuable. Knowing this, I think, is key.
Yeah, so the FDIC has tried on several occasions to increase the liability that directors shoulder in the context of a resolution by trying to set aside the state's business judgment rule. And basically, what the business judgment rule says, if directors are acting in good faith, their decisions are going to be upheld. They're not going to be subject to liability for these good faith decisions that they make. The FDIC has tried to transplant that with a sort of a federal common law rule in a couple of different cases. And ultimately, courts have said, no, the business judgment rule continues to apply. But if you look at that long list of constituencies included in the list of duties, I think there's some question about what the FDIC is trying to do with the rule, and whether by expanding the list of constituencies to include depositors, creditors, the public, regulators, whether you're trying to undermine the business judgment rule. Now, personally, I don't think they've been clear enough in the context of the proposal to set this federal common law rule. I think that would be to rely on this proposal to do that would be challenging. But it is a question, and because they've tried to do it twice before to undermine the business judgment rule in the context of resolution. So we're concerned. We would be concerned if during a resolution scenario the FDIC cited this authority to overrule the state's business judgment rules. That's sort of how it tracks, Andrew. I hope that was.
Yeah, no, that's good. It's an important point that it takes a little elaboration, but it's an important point to note here. I just want to go one last question for you, Brandon, is about the authority of the FDIC here. You referenced that the corporate governance right has long been reserved for the states. In your view, has this proposal gone too far? Has it intruded into, in an unpermissible way, a legally challengeable way, the authority of the states?
Yeah, I think as you look at all the cases that are coming up to the Supreme Court, whether the major question doctrine, Chevron deference, if you go in and read Section 39 of the Federal Deposit Insurance Act that the FDIC cites as authority, very vague, high-level justification. And whether that's sufficient to preempt, again, traditional areas of state law, I don't see it. I don't see it in Section 39. I do think it's something that institutions would have to consider in the context of a decision to challenge the application of the rule, whether there are other parties that may be interested in challenging the rule. And Patty, I think Patty made another excellent point, is that the standards that the FDIC would apply, in addition to being very strict and very enforceable, apply all the way down to institutions at 10 billion, at the 10 billion asset threshold, and subject to the FDIC's discretion to more complex or higher risk institutions, undefined, below 10 billion. Well, the FDIC, that's significantly different from what the OCC has in place as it relates to best practices around governance, and that applies at the $50 billion threshold. And then the Fed has requirements that it brings into play at the $100 billion threshold for prudential standards. So the differences across the agencies, particularly for state chartered institutions that have a holding company that may also be regulated by the Federal Reserve, those differences are real and can create some challenges from a state regulatory standpoint, but also from a regulatory arbitrage standpoint.
I think this is a good place for me to ask the first question that we've received, which is whether or not the new guidelines would be likely apply to, say, fintech banks that are less than $10 billion in assets. Is that the type of institution that reasonably would be expected to have to comply with the guidelines?
Well, I mean, you'd have to ask the FDIC that question, but given the focus on third-party risk management, banking as a service, BSA/AML, more recently, I think it's a good bet that would be one of the factors that the FDIC would consider.
Dale, I'm going to just turn to you now, and I'm going to step back and, the FDIC, gave a broad, as Brandon mentioned, broad statement that these guidelines are needed because it improves safety and soundness of banks. What's your view about is this proposal needed? Banks are also highly regulated, as we all know. Is there a problem here that needs to be solved that can't be addressed by existing tools?
Sure. Thanks for having me, Andrew. Let me start by saying thoughts and observations of my own. ABA's comment letter to the FDIC filed on the deadline is pretty clear where ABA stands. If I trail off or go down a false path that conflicts with that, I doubt I will. But if I do, thoughts about it. To get to the heart of your question, I won't go so far as to say the proposed guidelines are a solution in search of a problem. However, I'm firmly of the opinion, and ABA is too, that FDICs fail to adequately state the reason for their need. If you look to the proposed guidelines in footnote 9, the FDIC states, and I'm quoting here for a bit, the FDIC report on the failure of Signature Bank in 2023 found that the root cause of the failure was poor management without adequate risk management practices and controls. Okay, FDIC is raising the specter of highly public, tending on the larger side, but not the largest banks' failures. And it's clearly in the best interest of the industry and the country more broadly that the industry, participants adhere to appropriately high standards. And obviously that the Deposit Insurance Fund of the DIF not experience reasonably avoidable losses. That said, that report that FDIC references, it's not that long, so I'd recommend it to folks. The FDIC plainly lays out that it accurately, precisely, and all importantly, timely identified the risk most substantially contributing to those failures, the ones that the FDIC is citing as basis for the need for these proposed guidelines. They identified those risks well before the failures actually occurred. And we'll get to how in a moment, I know, but suffice it to say, with respect to that failure, and also with respect to its report on its supervision of First Republic, FDIC wasn't hampered by a lack of sufficiently robust tools. They have sufficiently robust tools. They were hampered by a largely yet explained reluctance to use those tools. I'll say, stepping back and sort of thinking human to human, faced with that coverage and the questions over the high profile failure, I'd say it's that knee-jerk impulse to attempt to avoid similar failures by imposing highly prescriptive guidelines. That's understandable. Our wanting to avoid pain, that's just deeply ingrained in our human nature. But that's not an adequate reason, right? The proposed guidelines would fundamentally reshape already prudently managed, closely supervised institutions, as you laid out, Andrew. And given the FDIC's current failure to explain and articulate their need, and also to sort of take a beat and make sure that any proposed standards it does ultimately adopt are principles based and allow for a variety of already well regulated, smoothly functioning institutions to continue in the way that they deem fit for themselves, obviously in accordance with broader guidelines. But that's why we've urged and continue to urge for the FDIC to withdraw the proposed guidelines. I know we'll get into a little bit finer details, but that was a long answer. The short answer is no, they're not needed. Sorry.
So I want to take the next step is we've heard a little bit about how the OCC and the Fed already have kind of existing guidance on governance for banks over $50 billion. Can you I think it'd be helpful here to kind of note talk a little bit more about how the FDIC's proposal differs from those, and whether or not do they sync up appropriately, or are there differences that will as institutions, particularly as they grow and move into, say, the categories for the $100 billion guidance that the Fed has, is that a smooth transition, or are they substantially different in approach?
They're substantially different in the approach in two very meaningful ways that I think are easy to explain in our short time together. First, as others have noted, the proposed guidelines are highly prescriptive. not only in absolute terms, but also in comparison to the OCC and Federal Reserve's existing heightened standards. That's the first piece. That fundamental flaw, as Larry, I believe, termed it, is magnified by the second piece of my answer, and that's the legal differences among Section 39 guidelines and guidance. The OCC's heightened standards, that they're enforceable guidance. So, but they're principles based. And enforceable guidelines, but they are principles based. The Federal Reserve heightened standards, those are guidance, which are strictly not enforceable under Section 39. Said differently, the FDIC's proposed guidelines are not only more stringent and inflexible in a lot of ways that they do need to be flexible, but the risks are magnified because of the legal differences in enforceability.
Now, okay, so we have these differences then amongst the agencies and how they approach governance. So the question always comes back to when we have these differences is, what are the implications for the charter? What is the value of this proposal for the FDIC charter, and whether or not, in your view, Dale, this impacts on how banks might determine whether to opt to be a national bank or be a Fed member bank. You think there's are the differences significant enough that you think it would cause institutions to think about which institution that they would like to have as their regulator?
Yeah, I won't make the mistake of bearing a one-word answer at the tail end of another longer answer. Yes, absolutely. So charter shopping, it's obviously a hot topic, and it's going to continue to be a hot topic, until we see what the FDIC does. And I think beyond that, it'll move from a hot topic to a matter of immediate dire consideration. The proposed guidelines, they're going to have a significant impact on our nation's dual chartering framework, which I think everyone on this call can agree is not only historically, but going forward, its very viability is important to our unique structure and the resiliency of our banking industry. Again, this is my perspective. I would say, faced with the proposed guidelines, irrespective of what actually comes out of the FDIC, I think a board would be remiss not to consider a charter conversion, or at least prepare for its eventuality, because there are going to be such significant differences in how an FDIC examined institution is going to be able to conduct its business within settled principles of prudent corporate governance compared to an institution that's examined by the OCC or FRB.
And then maybe I'll just look at last question is, we have seen it with a lot of proposals coming out of the agencies lately, particularly Basel Endgame being at the top of that list. But now it looks like with this proposal is that they don't necessarily reflect the diversity of the business models and organizational structures of U.S. banks. Can you talk a little bit about that and how right now there's a broad diversity of approaches and how this proposal could impact that?
Sure. I'll first note by just quickly referencing how the FDIC does things currently. And its continuous examination process, or SEP, already provides specialized examiners intimate, uninterrupted access to these institutions, these very institutions. The SEP threshold's also 10 billion in assets. So that's through its current process, it is capable of recognizing, as you put it, the diversity of business models and organizational structures within the would-be covered institutions. What I will say with respect to those institutions outside of the SEP context is that there is a far more heterogeneous population of banks than the populations that are subject to OCC or FRB's heightened standards. We can look at the population of would-be banks, and we're going to find it's quite a few names that everyone on this call and listening in, would sort of pop to mind when you think big bank. But there are also small regional banks. There's family-owned banks, a handful of them actually. There are banks in geographically remote locations. I'm sorry, I forgot who raised it. Brandon, I believe it might have been you. Talking about the differences not only among state law and the fiduciary standards that are relevant to them, but these are state chartered institutions. The various states have requirements related to directors' domicile in their, within their borders. So already, if you our econ team was nice enough to run just based on call report data, the list of banks that would be subject to the proposal includes banks in Hawaii and Puerto Rico. If you want to get more geographically remote in the U.S., then those two, best of luck to you. And those two, in addition to being geographically remote, also are a lot more homogeneous in terms of personal characteristics than the rest of the country as a whole. And they're going to face greater difficulty filling those directorships. You've got other banks that share entire boards with a parent holding company, subject to vastly different, far more flexible standards at the OCC and FRB. And as Patty and Larry, I believe you both mentioned, there's a whole host of banks right below that $10 billion threshold. Brandon, if you mentioned it, sorry, you've really got to take a look at that compliance timeline that everyone's talked about. And when you're faced with a 0-day compliance timeline, a board could not execute its fiduciary duties if of a covered institution below that threshold if they aren't preparing for it already. So in short, again, it's a far more heterogeneous population of banks that will be subject to it. And that's going to create far greater difficulties when you pair that with the highly prescriptive standards that the FDIC has laid out. And as Patty said, appears to be willing to move forward with it, at least as to some of them.
Dale and Brandon raised the issue about recruiting new directors and officers as a result of this guidance. I'd like to hear kind of, Patty, your kind of practical take on as somebody in the marketplace in this area. What's your view about the impact on recruitment and also selection of directors? There's some new requirements here on how boards are supposed to be composed.
On that point, I think that Brandon and Dale have said it well, right? It's depending on the size and the location of the organization, it is going to be hard to attract talent, right? If you're in a large metropolitan area, there's maybe more people who have the backgrounds in risk management and financial services and credit and compliance and other issues that you need to have on your board. If you're in more remote areas and if you're in smaller communities, it's going to be harder to pull that together. And then when you combine that with the issues with respect to board independence and the other corporate governance issues, if they actually are adopted, it will make it much more difficult to attract talent. The same way that boards struggle to get some of the financial expertise they need for their audit committees, they may struggle to get the risk management and other expertise they need to add those board members. So I do go back to something I said earlier, and I think that everybody on this call agrees, is that the idea of adopting this rule to fill what is a perceived gap, essentially between the $10 billion and $50 billion organizations that are state regulated, and all states have different regulations, right? It's not one size fits all across the country. I think the idea was to bring it more in line of what the OCC and the FRB are applying to more larger, complex organizations. In our view, and I think everyone on this call has said it as well, risk management is a basic tenet in the financial services industry. And if you don't have good corporate governance and risk management, you're not going to survive. That's a rule of thumb. So what our view is when looking at this is really what I said in probably my first couple of comments, is that the FDIC, if they could harmonize some of this with the OCC and the FRB and come out with a rule that the industry can manage through, it would be much more advantageous to the industry as a whole. And especially because as organizations get larger and they pass the $50 billion mark and they pass the $100 billion mark, you don't want to have two regulatory regimes. It impacts competition, it impacts costs, it makes it more difficult to run your organization, it impacts M&A activity. It creates more problems than I think that this was really intended to solve.
Well, that's some good practical advice here. So I've got another question. Well, I just want to be responsive to our viewers. As the question is, do you believe that the implied intent of these proposed guidelines is to motivate state non-member banks to convert to the OCC or Federal Reserve so the FDIC can better concentrate on supervising smaller community banks? Any view? I'll turn it to Brandon.
I'll take a run at the. I don't think that's the basis for the rule. Honestly, I sort of agree with Patty. I think they were trying to come in line with the OCC and the Fed, and I just think they did a bad job of doing it. You know, if the Fed and the OCC and the FDIC got together and formulated some best practices in this area, I think it would be an improvement over certainly the FDIC's proposal. And it goes back in a way, I think, to the justification for the rule, setting aside the thin justification for the rule as a whole, but with the specificity of the FDIC's rule, what makes that approach the best approach to corporate governance and risk management? Why can't there be other models that meet that? And what is the deficiency in those other models? And the FDIC just hasn't explained that at all in the context of the rule. And I think that's an important part of justifying it, given the significant detailed micromanaging approach that's included in the rule.
Thank you all for joining us today.
Thank you for having us.
Thank you for having us.
Thank you, Andrew.